Assalamualaikum warahmatullahi wabarakatuh. Kita mulai perkuliahan kita pada pagi hari ini dengan membaca lafaz basmalah bersama-sama. Bismillahirrahmanirrahim. Pada hari ini kita kehadiran dosen tamu dan dari Bayero University dari Nigeria, dan beliau salah satu ahli hukum internasional dari Departemen Hukum Internasional yang ada di salah satu negara yang ada di Bayero University di Nigeria. Dan kemudian pada hari ini kita akan mendapatkan penjelasan dari beliau berkaitan dengan bagaimana penerapan hukum internasional yang ada di Nigeria, sehingga kita punya perspektif sejauh mana negara-negara di Afrika termasuk yang ada di Nigeria khususnya dalam mengaplikasikan hukum internasional. Dan sebagai salah satu bentuk penugasan hari ini, seperti biasa nanti Mbak Rahma akan mengirimkan kertas responsi itu sebagai bentuk kehadiran dan minimal 1 halaman penuh tanpa spasi. Dan nanti silahkan bagi yang bertanya, saya akan berikan sesi kurang lebih 2-3 pertanyaan, dan kemudian nanti akan saya catat nama dan nomor mahasiswanya. Okay, dan I think because this is a regular and bahasa students, so I think during your presentation, I think I will just stop you after maybe 3 slides or 4 slides, and then after that I will do some summarize in bahasa Indonesia. Okay, so without further ado, I would like to ask Professor Kabiru Adamu to start, and the time and the place are yours.
So thank you very much. Assalamu alaikum. Good. So my name is Dr. Kabir Adamu. I'm a lawyer and lecturer from Nigeria. I lecture in a public university, and I've been teaching for the past 15 years. So I am here on the invitation of Universitas Islami, Indonesia, UII, and let me use this opportunity to thank Dodik. He has been taking care of me since the time I came, and I found the students very kind, very eager to learn, especially from our own experiences in Nigeria. So the topic I have for you today has to do with the application of, let me have the title, yes, International Law Application in Nigeria. So international law is a law that applies all over the world. It applies to all independent countries. In most cases, whether as a country you joined the United Nations organization or you are not a member, international law applies to you. So in the case of Nigeria, Nigeria is a country in West Africa. It was colonized by Britain. It got independence in the year 1960. So since that time, Nigeria has been playing an important role in international law. Nigeria is a member of United Nations organization. It was one time a member of the United Nations Security Council. It is a member of most important bodies of United Nations organization, like the United Nations Commission on Human Rights, United Nations Environmental Programs, and other international organizations. So therefore, international law is very, very important as part of the laws regulating Nigeria. So that is why I'm here to share ideas as to how international law apply in Nigeria for the sake of your own knowledge, so that you will be questioning how international law apply in Indonesia. What are our own experiences with respect to how international law apply? What are the rules relating to its application? And what can Indonesia learn, especially Indonesian students? Why? Because it is possible that one day some of you here will be at the United Nations, either as legal advisors, either as ambassadors. Maybe you'll be lucky they take you to Nigeria as ambassador to Indonesia. So you need knowledge about Nigeria and how international law applies. So I don't know whether I should give you time to explain to them.
Hukum internasional dipandang merupakan ilmu yang sangat penting di dunia. Terutama saat ini hukum internasional kita pahami bahwa hukum internasional itu diaplikasikan di banyak negara. Sifatnya yang universal dan kemudian dalam banyak hal banyak negara mulai tunduk dan patuh terhadap aturan-aturan yang ada di dalam hukum internasional. Dan hukum internasional ini banyak juga melahirkan banyak organisasi-organisasi internasional, seperti organisasi di bawah Perserikatan Bangsa-Bangsa atau United Nations. Di situ mereka banyak mengaplikasikan dan memiliki kewenangan untuk menerapkan hukum internasional. Dan kita pun juga berharap nanti kalau kalian belajar ilmu ini, kalian bisa bekerja di tingkat internasional, seperti mungkin di Perserikatan Bangsa-Bangsa, mungkin juga di organisasi PBB yang berkaitan dengan pengungsi, atau organisasi yang menangani permasalahan-permasalahan internasional lainnya.
Thank you very much. So, if we go over the slides, next slide. Okay. So, this is my own information. These are my qualifications. For instance, I have LLB, which is what you are doing now, right? Yes. I have Master of Laws, and I have PhD in law. So my current job function is Associate Professor of Law in this university, Bayero University in Kano, Nigeria. Okay, so next slide. So this is just a repetition of my qualifications. So now, this particular slide will give you an idea of our discussion for today. So what is it saying? It is saying that this presentation will give you an overview of the meaning of international law and how international law applies in Nigeria. And I said international law is part of the laws and the legal system in Nigeria. So it is part of our legal system. It has been practiced since before Nigeria's independence. And after Nigeria got its independence, it continued to apply. Why? Because Nigeria plays an important role in international law and international diplomacy. So, like I said from the beginning, Nigeria is a member of the United Nations. It was a member of the United Nations Security Council. So that's to tell you that Nigeria plays an important role in diplomacy. So this presentation will tell us how international law apply, what are the challenges and problems which international law faces in Nigeria. Then at the end of the paper, I will now give suggestion and recommendation on how to solve some of these problems. So the next slide, please. So, this slide explains that Nigeria was colonized by Britain in the year 1861. In the year 1861. And we got our independence in the year 1960. So, before that time, we had several communities living in Nigeria, and they practiced international law. We had kingdoms, we had empires, so they used to trade among themselves. Why? Because Nigeria is a big country. It is cycled by other countries. Countries in Niger, Benin, Cameroon. So that means these empires that are closer to the border have been practicing international law, trading, sending diplomats. In this respect, they send ambassadors in between themselves. So colonialism now brought the country together. So after colonialism has merged all these communities in 1914, then there was the application of international law by the British. Because the British now were the rulers of Nigeria. So they enter into agreements on behalf of Nigeria. So that is to show you that international law has been applied before Nigeria, then after the coming of the British through colonialism up until this day. So it continued to apply up to after our own independence. And now Nigeria is a major player in international law and diplomacy. So that is why this discussion about application of international law is good and is important. Yes. So next slide. Oh, you.
Jadi kita tahu bahwa Nigeria itu kan dijajah oleh Inggris dari tahun pertengahan abad ke-18, dan pada saat dijajah oleh Inggris, Inggris menguasai Nigeria, dan kemudian Inggris sendiri juga mempersatukan suku-suku kerajaan yang ada di Nigeria, karena selama ini di Nigeria itu banyak ada suku-suku dan kerajaan dipersatukan oleh Inggris. Dan kemudian Inggris pun mempraktekkan hukum internasional. Inggris mewakili Nigeria untuk melakukan perdagangan, untuk melakukan diplomasi, sehingga sampai hari ini apa yang dilakukan oleh Nigeria itu adalah bagian dari apa yang sudah dilakukan oleh Inggris sebelumnya. Sehingga sekarang Nigeria sudah mulai banyak melakukan diplomasi perdagangan dan kerjasama lainnya. Bagi yang baru datang silahkan membuat summary ya, 1 halaman, kertasnya bisa minta di belakang.
Thank you very much. So now, before I go into this slide, I need to define what is international law. So, scholars have defined international law according to their own perception. So, but the major meaning of international law is that it is a law that applies between countries. Any law that applies between countries, for instance, Indonesia and Nigeria, the law that regulates their relationship is called international law. So, previous definition of international law was problematic because the definition was given by Western scholars. And the way they define international law is that it is a law meant for civilized countries. Any law made to apply to civilized countries. So, by civilized countries, they mean European countries. So Nigeria, Indonesia, Malaysia, they are not included in the definition because we are not Europeans. Why? Because they said we are not civilized. When they say civilization, in their own thinking, it has to do with religion, Christianity. So any country that is not a Christian country, then it is not civilized, even if it has a perfect legal system. For instance, most countries follow the Islamic religion, and Islamic law has rules relating to international relations, even before the formation of the European empires. So that definition is no good for developing countries, because it is saying that since we are not civilized, the international law will not apply to us. That means we cannot engage in international relationship with other countries. So because of this problem of definition, many scholars now from developing countries criticize the definition. So the good definition for international law is, it is a law that applies to states and non-state actors. States and non-state actors. So whether the state is civilized or not, insofar under international law, it has satisfied the requirement of statehood. It is recognized by United Nations or 5 major powers, permanent members of United Nations Security Council, then it is a state. So.
Tadi beliau mendefinisikan apa itu hukum internasional. Menurut beliau, hukum internasional itu definisi yang seringkali kita dengar itu adalah hukum yang berlaku di antara banyak negara, atau countries gitu ya, negara. Tapi countries di sini maksudnya itu adalah negara-negara yang beradab atau civilized, yang sudah memiliki peradaban. Dan umumnya negara-negara yang civilized ini itu agak dekat dengan definisi Christianity, Kristen gitu ya. Jadi dianggap kalau negara-negara yang dia tidak mengadopsi Kristen atau dia mengadopsi agama lain, itu dianggap belum bisa masuk dalam kategori definisi hukum internasional ini. Karena hukum yang baik harusnya untuk hukum negara-negara yang baik begitu, untuk negara-negara yang maju. Nah, kemudian beliau melakukan redefinisi terhadap hukum internasional. Redefinisi itu menjadi hukum yang berlaku for all states. Jadi untuk semua negara, tidak peduli apakah negara itu majority Muslim atau Kristen, atau negara itu mengklaim sebagai negara demokrasi yang mana semua agama ada. Termasuk juga hukum ini juga berlaku kepada non-state actor atau aktor-aktor selain negara.
Thank you very much. So now, how do we know that this is international law? We will know that a law is international law when we go back to the provision of Article 38 of the International Court of Justice Statute of 1945. So Article 38. Article 38 of the ICJ statute says that international law comes from some sources. So these sources are: number one, customary international law. Customary international law. Number two, international treaties and agreements. International treaties and agreements. Number three, general principles of law found in civilized countries. General principles of law found in civilized countries. Then number four, writings and opinions of scholars. Writings and opinions of scholars. Number five, judgments of international courts. So this is international law. So international law comes from 5 sources, and you will understand that when you go to Article 38 ICJ statute. It's a treaty, international treaty that established the International Court of Justice. So, and it says international law has 5 sources. It comes from these 5 sources. Customary international law. And customary international law is the custom practices between countries which they have been observing for many years. So much so that they consider it as part of their law. So many, many years, countries have certain practices. For instance, under international law, if you go to war, then when you go into the war and you have prisoners, you don't kill them. When they surrender, you don't kill them. You arrest them. So this is customary international law. Empires, many, many thousand years ago, it's a practice when you are fighting and your enemy said, I have surrendered. So it's a prisoner. You don't kill him. Number 2, example of customary international law is sending ambassadors to countries. It's a practice empires have been doing before modern international law. Then trading. There is a system of trade between countries. So all these are part of customary international law, from custom practices. Number 2, treaties, agreements between countries. Countries sit down and write agreement in relation to a particular issue of interest. So that treaty now becomes part of international law. Then number 3, general principles of law. If there is a problem, you don't have customary international law, you don't have treaty regulating an issue in international law, you go back to general principles of law that are found in civilized countries. What this means is that you go to laws, old laws, civil law for instance, English common law, Russian law, Chinese law. So if there is a principle there that can regulate international law, you take it and it is part of international law. Then number 4, you have decisions of international courts, like the ICJ, International Court of Justice, like the ICC, that's the International Criminal Tribunal, right? International Criminal Court. Then you have International Tribunal for Law of the Sea, ITLO. So their judgments that they pass is now part of international. And lastly, you have writings of scholars. They have written books, opinion about international law. Then it becomes international law. People like Oppenheim, Lauterpacht, and the rest. So these are the sources of international law, and we need to understand it before we go to how it applies in Nigeria. Yeah.
Jadi sumber-sumber hukum internasional seperti yang kita pahami itu diatur dalam pasal 38 Statuta Mahkamah Internasional. Di dalam pasal 38 tersebut disebutkan sumber hukum internasional itu ada 4. Yang pertama adalah hukum kebiasaan internasional. Yang kedua adalah perjanjian internasional. Yang ketiga adalah prinsip-prinsip umum hukum. Dan yang keempat itu adalah pendapat para sarjana. Dan yang terakhir itu adalah putusan-putusan pengadilan, terutama putusan-putusan pengadilan internasional seperti Mahkamah Internasional maupun Mahkamah Pidana Internasional. Dalam hal ini sumber-sumber hukum internasional menjadi salah satu bagian ketika kita belajar hukum internasional. Maka sumber-sumber itu harus kita pahami dengan jelas. Dan ini nanti ada kaitannya dengan penjelasan beliau setelah ini, bahwa sumber-sumber hukum tersebut sebenarnya itu juga diadopsi oleh Nigeria. Nah, sejauh mana pengadopsiannya nanti akan dijelaskan oleh beliau.
Okay. Thank you very much.
You're
so
welcome.
now, this slide explains how does international law apply in Nigeria. But before you understand this, you need to read this theory about international law application. So the theories are 3. We have the monist theory, which is called monism. We have the dualist theory, dualism. We have the nihilistic theory, nihilism. So these theories were explained by scholars that before you apply international law, you need to look at these three theories and how these theories govern the application of international law in any given country. So next slide. Yes, next slide. So this is the explanation of the theories. The first theory is the monist theory. Monist theory. So this theory is saying that international law is superior than national law. Meaning, international law that apply between countries is bigger, is senior to law that applies within that country. So, typically it means international law, for instance, is bigger than Indonesian law, the law that applies in Indonesia. So what does this mean? It means that whenever you are going to apply international law in Indonesia, then international law is superior than the law of Indonesia. So it means that the courts in Indonesia must apply international law in Indonesia without any form of restriction. They don't have to seek the consent of the courts because automatically they come in, they apply because they are senior to Indonesian law. So the supporters of this theory are scholars called for Martin and Skelton and John Austin. All these are scholars who have written a lot of books supporting this theory that international law is superior than any national law operating within a country. Yes.
Untuk mengetahui dan mempelajari sejauh mana aplikasi hukum internasional di negeri ya, ada 3 teori yang bisa dipakai. Yang pertama adalah teori monisme, yang kedua ada teori dualisme, dan yang ketiga nihilism theory atau nihil teori. Nah, teori monisme ini sebenarnya menganggap bahwa hukum internasional itu lebih tinggi daripada hukum yang lain. Ini yang menyebabkan teori monisme ini karena dianggap monisme ya. Jadi ada satu aturan yang dia lebih tinggi. Jadi hukum nasional harus tunduk pada hukum internasional.
Okay, thank you. Next slide. So, this other theory is called dualist theory. So, this theory is saying that international law and national law are different laws. They are different in nature, in character, in terms of function and application. Therefore, they are two equals. They are like two strong brothers. Each one is independent. So what this means is that whenever international law is to be applied in a country, it must follow the process of domestication in that country. You cannot just take it and apply it like the monist theory said. No. You must bring it before your legislature, then they give consent, they domesticate it, then it applies in that country. And you see, this idea is connected to positivist view of the law, which in practice says that international law should not be superior to customary to national law. Therefore, whenever it is to be applied, it has to get the approval of that country. So depending on the system in that country, maybe the president will have to approve it, maybe the legislature will have to approve it, but it will not just apply directly. So that process is called domestication. And this idea is supported by scholars like Eric Triffitt, Dionisio Anzilotti, and Oppenheim. Yes.
Salah satu teori yang kedua itu adalah teori dualisme, di mana untuk dalam teori dualisme itu hukum internasional dan hukum nasional itu terpisah satu sama lain, tidak terikat satu sama lain. Dan dalam teori dualisme ini negara itu tinggal memilih memposisikan hukum internasional dengan hukum nasional itu dua rezim yang berbeda. Ketika negara memahami bahwa dengan teori dualisme, maka ketika negara memposisikan hukum internasional itu berbeda dengan hukum nasional. Jadi hukum internasional berbeda dengan hukum nasional, dan hukum internasional terpisah dengan hukum nasional, dan hukum internasional untuk dapat diadopsi dalam hukum nasional maka membutuhkan ratifikasi, dan kemudian kalau hukum nasional akan diadopsi, hukum internasional juga bisa, tapi melalui proses yang sangat panjang.
Thank you very much. The next slide. So this is the last theory. So this theory simply is saying that national law is superior to international law. The laws of a country are bigger than international law. And supporters of this theory are Sukami and Listed. So what this means in practice is that countries are powerful, they are sovereign. So their laws are also powerful and sovereign. So therefore, they don't have to seek the consent of any country, or they seek the consent of international law. So that is why you tend to see in modern times, countries like the US are saying that our interests first. Trump now is saying interests of America first. He doesn't care about international law, international trade law. He doesn't care about protection of human rights. He doesn't care about agreements between countries. That is why Trump now is putting tariffs on countries, all in line with this theory that domestic laws, national laws are superior than international law. Yes.
Nihilism teori itu menganggap hukum nasional itu lebih tinggi daripada hukum internasional. Mengapa demikian? Karena hukum nasional itu memiliki yang namanya kedaulatan. Kedaulatan itu memastikan negara itu boleh mengurusi dirinya sendiri, dan dia punya kewenangan penuh untuk mengatur apa saja yang ada di wilayahnya. Sehingga kalau ada negara yang menganut teori nihilisme ini, dia menganggap hukum nasional itu jauh lebih tinggi karena mereka lebih berdaulat dan harus disetarakan dengan negara-negara berdaulat lainnya.
Thank you very much. So now, since we know all this theory, that will help us to see how international law is applied in Nigeria. To see whether Nigeria adopted any of the theory, and to see the problems that this application is causing for Nigeria. Next slide. So now, Nigeria adopts the dualist theory. Nigeria adopts the dualist theory of application of international law. That is to say that Nigeria recognizes international law, but that international law is not superior to Nigerian law. So therefore, when you have any principle of international law and you want to apply it in Nigeria, then that principle or that law must be domesticated And how is that domestication happening? It means that you take that law to the National Assembly, the legislature. And the National Assembly will now pass or enact a law. That particular international law that you want to apply in Nigeria, it will be transformed into a local law. And the National Assembly will now give consent, and it becomes a law in Nigeria. If that is not done, if you don't domesticate it, then it will not apply. No matter how beautiful that international law, principle, or treaty is. So that is to say, before any international law apply in Nigeria, it must satisfy this condition. One, it will only apply subject to local legislation, meaning a law in Nigeria must allow it to apply. That is number one. Number two, it must be adopted, incorporated, and transformed as a local law. Meaning, if for instance you have the United Nations Declaration on Human Rights, it's a treaty, and you want to apply it in Nigeria, then you take that particular law to the National Assembly, and they will now enact a law accepting that United Nations Declaration on Human Rights. Then that is how it applied based on local law. Number three, it means that that application is a constitutional one. What does that mean? It means we have a constitution, the supreme law in Nigeria, which says you must do that. So it is a constitutional issue, not ordinary issue. And it must pass through legislative requirement. It means that the president of Nigeria will not just accept that law. No. He has to take it to the National Assembly, the legislature, and they now pass it into a local law. Yes.
Bagaimana dengan Nigeria? Nigeria itu tadi menganut dengan mengadopsi dualisme teori, yang mana HI dengan HN, hukum internasional dan hukum nasional, itu dua sistem hukum yang berbeda. Dan hukum internasional akan diterapkan di dalam hukum domestik apabila ada domestication atau pengadopsian terhadap di dalam hukum nasional mereka sendiri. Dan ketika ada di Nigeria mereka mau mengadopsi perjanjian internasional, maka mereka harus memenuhi syarat-syarat sebagaimana ditayangkan dalam PPT ini. Yang ketiga misalnya harus disesuaikan dengan konstitusi dan juga disesuaikan dengan peraturan yang mendasar yang ada di negara Nigeria. Jadi tidak semata-mata ketika ada perjanjian internasional itu bisa diterapkan di Nigeria, tapi ketika akan diterapkan maka harus diadopsi terlebih dahulu, ada proses lebih lanjut terlebih dahulu. Mungkin nanti beliau menjelaskan, namanya sih ratifikasi. So the adoption usually using the ratification, right? When you say domestication, is that similar with ratification?
No.
Oh, it's different.
So you know the process is this: if Nigeria is interested in a treaty, they will go and sign the treaty. So after signing, they will now take it to the country. So the president, for instance, he will send his minister for foreign affairs, or he goes and signs the treaty. He will now take it to the country. So, and he will now inform the National Assembly legislation that there is a treaty I signed for Nigeria. So I want you to domesticate it. So what does that mean? It means that he will give a copy to the legislature. They will go over it. This is what they will debate whether it is good. Then they will now enact a law from the treaty.
Is that separate law or the treaty become the law?
No. The treaty will not become a law until you have another other local law. So for instance, you have the United Nations Declaration of Human Rights Treaty Convention. So if the president takes it to the National Assembly, then they will call it United Nations Declaration of Human Rights Enforcement Act.
Okay, the same like us.
Yes.
Yeah.
So after that, when it is done, it now becomes a law. Then the president will go and ratify the treaty.
Okay.
Yes.
Oke, jadi prosesnya ketika mau meratifikasi perjanjian internasional di Nigeria, itu jadi presidennya dia mungkin akan membawa dokumen perjanjian internasional itu ke DPR, dan di DPR nanti akan dibahas, diperdebatkan sejauh mana relevansinya terhadap kebutuhan negara. Setelah itu kemudian DPR akan mengesahkan undang-undang pengesahan dari atau undang-undang pengesahan dari perjanjian internasional itu sendiri. Sebenarnya prakteknya hampir sama dengan di Indonesia, cuman bedanya di Nigeria selain ada undang-undang pengesahan juga ada undang-undang yang bisa berlaku di tingkat negara. Dan karena perjanjian internasional kan berbahasa Inggris dan kadang-kadang mungkin interpretasinya bisa berbeda, sehingga kemudian diundangkan kembali dalam bentuk peraturan perundang-undangan yang spesifik di Nigeria.
Thank you very much. So the next slide. So, this is the provision of the Constitution of Nigeria. We have a Constitution, the Supreme Law, which is called the Constitution of the Federal Republic of Nigeria of 1999. It was made in 1999, so it's still applied, even though it has been amended, but the name is 1999 Constitution of Nigeria. So it is that law that says you cannot apply international law in Nigeria unless you domesticate it. You take it to the National Assembly. So this is the quotation. It says no treaty between the Federation and any other country shall have the force of law except to the extent to which any such treaty has been enacted into law by the National Assembly of Nigeria. So like I said, if you have a treaty signed by Nigeria, you must bring it to who? To the National Assembly. And they will enact a law accepting that treaty. Then this process is called process of domestication. If you don't do that, then that treaty will not apply. And our court, the Supreme Court of Nigeria, the highest court, interpreted this section and says this section is right in this particular case. Abacha versus Hawaii in 2001. So let me give you the facts so that you understand. This guy is a lawyer. So the police and army arrested him. When they arrested him, they took him to prison. They didn't take him to court. So he stayed in prison for many, many days. So he now sued the government. And the head of the government was Abacha at that time. So when he sued him, he said he has the right as a Nigerian not to be incarcerated in a prison. He has the right because international law, United Nations Declaration of Human Rights, and African Charter on Human and People's Rights give him a right as a Nigerian, as a human being, not to be imprisoned without a reason. So when he said this in court, government now said no. The international law, which you quoted, United Nations Declaration of Human Rights and African Charter of Human and People's Rights, does not apply in Nigeria. And why? Because they have not been domesticated as required by this section. So, and the Supreme Court said yes, because our law says that they must be domesticated before you apply them. Yes.
Ya. Ini menarik sekali. Jadi di dalam konstitusi Nigeria diatur bahwa tidak ada satu perjanjian yang disepakati antara Nigeria dengan negara lain itu berlaku di Nigeria, kecuali apabila perjanjian internasional itu sudah disahkan dengan undang-undang oleh DPR. Jadi syaratnya perjanjian internasional yang ada di luar yang disepakati presiden itu harus disahkan melalui DPR mereka, National Assembly. Dan ini ada kasus menarik yaitu Abacha dengan Fahmi ini. Di kasus ini adalah seorang lawyer, jadi pengacara. Fahmi ini bertahun-tahun dia di penjara tanpa ada kejelasan. Dia itu di penjara karena apa? Nah, pembunuhan atau apa, dia nggak ada kejelasan, sudah bertahun-tahun. Dan kemudian Fahmi ini dia menggugat negara, dan pada saat itu nama negaranya itu Abacha. Kemudian is that federal state or salah satu negara bagian yang ada di Nigeria, dan itu digugat oleh si Fahmi ini, dan Fahmi menggunakan dasar yang ada di Deklarasi Universal Hak Asasi Manusia. Dia mengatakan bahwa di dalam salah satu pasal Deklarasi Universal Hak Asasi Manusia diatur bahwa seseorang itu tidak boleh ditangkap, ditahan tanpa ada kejelasan, tanpa ada alasan apapun, dan itu bagian dari hak atas dasar bagi dia. Dan akhirnya kemudian pengadilan menolak menggunakan Deklarasi Universal Hak Asasi Manusia itu dengan alasan bahwa deklarasi ini belum menjadi undang-undang dan belum disahkan oleh DPR yang ada di Nigeria. So this was rejected, the application of Universal Declaration. So this was the first case. Yeah. Jadi syarat agar perjanjian internasional bisa diterapkan di Nigeria, dipraktekkan oleh warga negaranya, harus disahkan dalam bentuk undang-undang.
Thank you very much. So the next slide. So since we now know that before you apply international law, you must domesticate it. You must take it to the National Assembly. So let me just explain practically how it works. If Nigeria is interested in any provision of international law, the president will now go and take that international law, and he will now draft a bill. He will draft a bill, and he will take it to the National Assembly, and he will tell the National Assembly that there is an international law provision which is good for Nigeria. I have seen it, or it is a treaty that I have signed on behalf of Nigeria. It is good. So I want you to pass it as an executive bill. So that means it is a bill, a law coming from the president. So they will share the bill to the members of the National Assembly. They will go over it to see whether there are problems with that international law. Because as we will see later, some international law provisions are not good for Nigeria because of culture, because of our religion. So that is the logic why they say it needs to be domesticated. So the National Assembly will say, we don't like this provision, we will change it. We don't like this, we will change it. So all those things that were changed under international law, we call them reservation of provision of a treaty. So after that, that law will be passed, and it will be taken to the president again, and he will sign it, and it becomes the law. Yes.
Menarik sekali. Jadi di Nigeria itu ketika perjanjian internasional itu harus dibahas di DPR, kadangkala pasal-pasal dalam perjanjian internasional itu tidak sesuai dengan situasi kondisi budaya di Nigeria, sehingga kemudian ada pasal-pasal yang dirubah di DPR. Nah, ini akan berdampak ada konflik antara perjanjian internasional yang disepakati oleh negara-negara di dunia dengan undang-undang yang ada di Nigeria. Akhirnya kemudian Nigeria mengajukan reservasi terhadap pasal-pasal yang ada di dalam perjanjian internasional. Nah, ketika reservasi ini disetujui oleh sekretariat atau mungkin negara-negara yang sudah tergabung dalam perjanjian internasional itu, maka kemudian hasil reservasinya itu akan diundangkan di dalam undang-undang yang ada di negeri.
Thank you very much. So, what happens if that international law is domesticated? Number one, it is now a law in Nigeria. Everybody must comply. That is number one. Number two, it creates an obligation on government. That obligation can be international. So that means, for instance, if you have the United Nations Declaration of Human Rights brought to Nigeria, it is now domesticated, it becomes a law. So our president now has obligation to go and ratify it at the United Nations organization. So that means it is his own obligation to do so. And whatever is inside it, it becomes mandatory for Nigeria to abide by. So if you have a provision in the United Nations Declaration of Human Rights that says, don't kill somebody, don't torture somebody, don't take away person's property, that means it is now obligation on government not to do that, because it has become a law against the government of Nigeria. It has to go and ratify it. It is now an obligation for Nigeria to comply with that particular law that was domesticated.
Ya, jadi di Negria itu untuk memastikan bahwa perjanjian internasional itu bisa efektif berlaku di wilayah Negria, maka itu harus melalui proses domesticated itu tadi. Jadi perjanjian internasional dibawa ke oleh Presiden, dimohonkan pembahasannya di DPR dibahas, baru setelah dibahas kemudian disetujui di DPR dan kemudian itu baru berlaku, sehingga terjadi efektivitas di sini. Perjanjian internasional sudah menjadi undang-undang, undang-undangnya berlaku kepada seluruh warga negara mengimplementasikannya dengan mudah, dan yang kedua, negara juga punya kewajiban untuk patuh terhadap perjanjian internasional tersebut. Dengan melalui proses ini, maka warga negaranya pun paham apa yang harus dilakukan, negaranya pun juga semakin bisa memantau sejauh mana pelaksanaannya terhadap di dalam hukum nasional.
Next slide. So, now, what is the problem with application of international law in Nigeria? It creates a lot of problem for Nigeria. And maybe this will be lesson for Indonesia, especially for you students that one day you become legal officers, you work for government, and you work for other institutions. So what are the challenges? Number one, you see, it is mandatory for any international law provision to be domesticated. So you cannot run away from it. This is mandatory. If you don't follow it, then it is a constitutional breach, which may lead to the impeachment of the president if he applied any international law if it is not domesticated. So this is a problem. A problem in the sense that it means that if an international law provision is good, is beautiful, which Nigeria is supposed to use or apply, and it is not domesticated, then it is not of legal effect. It will be unuseful. Number two problem is, at times, the president might not be interested in a particular rule of international law. He doesn't like it. And it is good. So he will not take it to the National Assembly for domestication. So this is a negative lack of interest. Number three, corruption. At times the president, if he likes a particular rule of international law, and he wants the National Assembly to pass it, he has to give them money so that they pass it, especially if they don't like the law. So this is corruption. Number four, you see that we have weak institutions. Why? Because at times the institution of governance, the National Assembly, is weak if the president is too powerful. So he can do and force them to do things. The number 5, there is ambiguity. Ambiguity in the sense that customary international law, based on the principles of international law, they said it applied directly in Nigeria, and it doesn't have to be domesticated. So some cases said yes, some cases said no. So it's not really clear. So, should I explain the others? Or?
Yes, please.
Okay, so next slide, please. That's number 5. Number 6, lack of cooperation between executive and legislature. They don't cooperate at times. Then, like I said, the executive might not really be interested in domesticating the treaty. Then lastly, some treaties conflict with culture and religion. So you don't easily come and domesticate them. For instance, if it has to do with some Islamic law provisions, for instance, under Islam, women are expected to cover their body. Right? In Islam, when it comes to inheritance, you give a man one portion, right? He will take 2 portions of a woman. That is according to Islamic law.
2 portions for men and
Yes.
1 for women.
Yes. So you see, the problem now is we have an international law, that is Convention on the Elimination of Discrimination Against Women. It says man and woman are equal. So when you are giving them any inheritance, you must give them equally. So this is in conflict with Islamic law. So when this law was brought before National Assembly for investigation, there was fighting, they refused it. Because Muslim members said, no, it is against our religion. Another example is Convention on the Rights of the Child. Under Islamic law, the age for marriage of a woman is different from the age of marriage under common law and English law. Because under English law, a girl must be 18 before she is married. But under Islamic law, age is determined by puberty. If you could remember our history in Islam, Prophet ﷺ married Aisha radiallahu ta'ala anha, right? At the age of 9 years, right? So, that means according to this law, which says that you must marry somebody 18, is in conflict with Islamic law. And in Nigeria, you can marry a girl insofar she is of puberty. She is 9, but she is big. You can marry her. So, these provisions of international law, they are very difficult to be domesticated in Nigeria.
Jadi di Negeriya juga ada permasalahan tidak semudah yang kita bayangkan ketika perjanjian internasional yang mau diadopsi itu kemudian dibawa ke ranah hukum nasional. Dan itu tidak mudah. Kenapa? Karena mungkin permasalahan berkaitan dengan mungkin karena pemerintahnya sendiri. Yang pertama itu karena persyaratannya. Persyaratannya mungkin bertentangan dengan ketentuan yang ada di dalam konstitusi negara. Kemudian yang kedua mungkin juga karena tidak adanya motivasi atau keinginan dari pemerintah eksekutif untuk meratifikasi. Kemudian yang ketiga mungkin karena korupsi, karena mungkin korupsi bagi-bagi uang gitu ya di DPR gitu, National Assembly gitu ya. Jadi agar disahkan, agar mudah disahkan, padahal mereka sendiri aturan-aturannya di dalamnya itu banyak sekali yang bertentangan dengan situasi yang ada di negeri ya, sehingga mereka melakukan korupsi. Atau juga weak institution karena lemah. Jadi karena mungkin presidennya, pemerintahnya, eksekutif powernya itu memiliki kewenangan yang luar biasa banyak, sehingga kemudian mereka lemah dalam hal mendiskusikan mana-mana saja pasal-pasal yang bertentangan dengan situasi yang ada di negeri kita. Atau ambiguitas, ini juga sama, tidak ada sinergi harmoni antara eksekutif dan legislatif. Kemudian juga sama Kemudian yang paling terakhir ini banyak sekali yang berkonflik dengan budaya dan agama. Seperti tadi disyaratkan kalau di dalam hukum Islam itu kan banyak aturannya itu, seperti misalnya salah satunya menikah itu boleh bagi perempuan yang sudah masuk pubertas gitu ya. Tapi kemudian ada konvensi internasional, yaitu konvensi penghapusan diskriminasi terhadap perempuan. Di situ disebutkan adanya harus equal gitu ya. Terutama waris juga kan, kalau perempuan hanya dapat separuh, laki-laki dapat 2 gitu ya. Laki-laki dapat 1, perempuan dapat laki-laki 2, perempuan 1 gitu ya. Nah kemudian menurut konvensi ini kan berarti kan bertentangan karena harus sama gitu ya. Tapi kalau yang ini pernikahan anak itu kan itu bertentangan juga dengan konvensi hak anak, karena hak anak itu baru boleh nikah setelah mereka masuk usia-usia tertentu. Nah ini ada konflik yang banyak sekali antara perjanjian internasional dengan kondisi lokal yang ada di negeri ya.
Thank you very much. So the last slide. So what are the solutions to this problem? Number one, the executive, they need to have a good relationship with the legislature when they are investigating the law. Then number two, we should eradicate corruption. The government should not be corrupting legislatures when they want to investigate international law. We should have strong institutions, especially the National Assembly is an independent body under our system of government. So they ought to be powerful. They don't have to be weak to be override by executive power of the president. Then number four, there is the need to clarify whether customary international law applies directly in Nigeria or whether it needs domestication. The last slide. Yes, so
Last slide.
The last slide, this is the summary of what I have discussed, and I mentioned some of the challenges and the solution. Thank you very much.
Terima kasih. Silakan, apakah ada pertanyaan boleh disampaikan dalam bahasa Indonesia. Jilbabnya diperhatikan. Ada 2 anak di sini yang melanggar. Tolong Mas Farhan bisa dibantu, ada cemiti di ruangan saya itu. Kemudian yang kedua, kalau boleh disampaikan pertanyaannya dalam bahasa Indonesia dan nanti saya akan menerjemahkannya dalam bahasa Inggris. Silakan. Ada pertanyaan? Sebutkan nama dan NIM juga kalau mau bertanya. Silakan. Do you have any questions? You may also address the questions in bahasa Indonesia and I will translate it. Silakan. Nggak ada? Oh, ada 1. Oke, boleh. Ada lagi yang lain? 2. Oke, 3. Oke, sudah cukup ya, 3 saja. Silakan yang pertama. Waalaikumsalam warahmatullahi wabarakatuh. Ya. Ini HI kelas apa? C ya. Oke.
Internasional customary law atau hukum kebiasaan internasional. Nah, dialektika ini kan juga sering bertabrakan dengan perjanjian inter itu sendiri. Apakah berbagai macam naskah akademik yang masuk ke dalam konteks pertimbangan rancangan undang-undang di Nigeria itu sudah mampu gitu untuk mengharmonisasikan antara perjanjian inter hingga prinsip hukum kebiasaan internasional sampai ke undang-undang Nigerianya itu sendiri, karena kan memang conclusion ini kan sebatas ejawanta akademis ya, tapi sudah contoh konkretnya atau belum? Terima kasih.
Ya, terima kasih. So the first question is about in Indonesia. Usually, before we draft a bill, a regulation, we also have academic research to propose the bill. So what are the urgency and then how far it can be implemented and so on? Is that the same in yours, or is just only the bill that proposed to the National Assembly, because in our side, usually beside the bill, we also have the academic research report. Yeah, in each article, in each content of the bill. Silakan. I think we will collect all the questions and then you will answer it. Silakan. Yang kedua, silakan. Mas, dibantu mikrofonnya dibawa ke sini. Ke sini dulu, ini yang lebih dekat, ini kan satu meja ini. Ya. Oke.
Oke, assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, nama saya Fani Alvareta dengan NIM 244100530. Dan Bapak Dodi izinkan saya langsung menanyakan pertanyaan dalam bahasa Inggris ya Pak ya. Oh ya. Okay, so I want to ask about is there any significant differences between international law in Nigeria in the pre-colonialism, colonialism, and post-colonialism till nowadays? As we know that in the colonialism, most of it was made by the British. So I want to know, is there any significant difference, especially in pre-colonialism and colonialism? And thank you.
That's a good question.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, nama saya Dea Adelia dengan NIM 244100585. First of all, thank you Professor for the materials. It's so insightful and interesting. So, jadi pertanyaan saya adalah berapa lama hukum internasional itu diterapkan ketika sesudah terjadi domestikasi di Nigeria itu? Ya, ya.
So how long? Because you say that there will be a domestication process, and how long usually it will take from proposing until they enacted?
Thank you very much. So let me start by answering your question. So if you have an international law provision or treaty, and the government, because don't forget, like I said, it must come through executive bill. It is the president that will take it to the National Assembly, not anybody. I will come to explain that in relation to his question. So the president, when he takes it to the Senate, because laws are only enacted by the Senate, those laws relating to treaty. Because we have two houses in terms of our own legislature. We have the Senate and House of Representatives. So the Senate, when it comes to domestication of treaty, is the one that will look at the treaty, not the House of Representatives. Why? Because this is like the senior house. They are more matured. That's what they said. They know what they are doing better than the House of Representatives. So the president will take it to the Senate president, the leader of the Senate. And normally when he tables it, he doesn't give them time. The law does not say he must give them time within which they are to pass that law. So it can take 1 month, it can take 2 months, it can take 6 months, depending on the international law. If the international law is complex, and it has a lot of issues that can conflict with culture and religion, so that means it will be debated many, many times before they arrive at a final law. So it depends on the type of international law. It can be 1 month, it can be 2 months, it can be 3 months, it can even be 6 months. At times, there will not be even law because they will not pass it. They will argue and argue, we don't like this treaty, we don't like this, they will throw it away. Like it has happened severally. So no time limit. That is our own answer.
Kurang lebih bisa 1 bulan, 2 bulan, 3 bulan sampai 6 bulan, dan prosesnya itu memang dari eksekutif, dari pemerintah. Dia akan memberikan permohonan kepada DPR-nya, National Assembly-nya. Tapi di sana itu ada 2, ada Senat sama ada DPR. Nah, biasanya lewat ketua senatnya terlebih dahulu disampaikan. Nah, nanti ketua senatnya itu akan kemudian meminta ada pembahasan lebih lanjut di tingkat DPR, dan itu membutuhkan waktu 1 sampai 6 bulan.
Okay, thank you. In answer to your question, whether we have this type of system in Indonesia where you need research, whether you need academic input to a bill before it is passed. Ours is not mandatory, but let me explain the process. In Nigeria, before a law is passed, it can take 3 forms. One, executive bill. So that law is proposed by the president. So we call it executive bill. He will take it to the National Assembly. Then there is member bill. What does that mean? It means member of the Senate, who is a member, will now propose the bill. So number 3, there is individual bill by a citizen. But in most cases, you hardly see that. You only see executive bill and member bill. So if there is a bill, before it is presented, So in answering your question, we in Nigeria, we don't have a process whereby a bill requires the attention or input of academics, so to speak, before it becomes a bill for presentation. However, like I said, we have a system in which before you pass a law, it must come through a bill through 3 ways. Executive bill, legislative bill, that is member bill, member of the legislature, or individual bill. Before they present the bill, they will go and do their research. When they do their research, they will draft version of the bill, that law. Then they have research assistants that are paid by government within the legislature. So possibly some of them have academics that they will take the bill to. That is, if it is an executive bill, they take it to experts, they look at it, but it's not mandatory. Or if it is a member of the legislature, he will take it to an academic that is an expert in that area. So they will now look at the problems of that bill. They will advise him, this is how you should draft it, this is what it should contain. Then he will now present it to the National Assembly. When he presents to the National Assembly, then it will be presented before the whole members. And that is what is called first reading of a bill. So members will look at it, scrutinize it, and they will give their own opinion. Then after first reading, it will be taken to committee. The legislature has committees in relation to each issue. So it can be an economic issue, it can be a judiciary issue, it can be a security issue. There are committees in the House. Then the committee now will do what is called public hearing. They will announce to the public, we have a bill that we want to pass. We want members to come and tell us their own opinion. So the committee will listen, they will take correction, they will now make amendment, then they take it back to the House. This is called second reading. So the House will now look at the bill again. If there are corrections to be made, they will make it. They can decide to say, take it back, correct this, correct that. They bring it. When they bring it back, that is called third reading. So first reading, second reading, third reading. Then after that, if it is okay, then they present it to the members of the assembly. And they will vote. Each member will vote. Yes, I like it. Yes, I like it. Yes, I don't like this bill. So they will count the number. The number that is higher, if it is, let us say, 40 over 50, that said yes, then they will pass this bill. If it is 40 minus 10, they say we don't like the bill, then they will reject the bill. So that is how it works. You understand? Yes.
Jadi hampir sama seperti kita. Jadi biasanya nanti rancangan undang-undang itu akan disampaikan dan kemudian mereka akan membuat semacam di DPR, mereka akan membuat kayak kalau kita pansus ya, panitia khusus kecil-kecil. Jadi ada yang membahas dari perspektif ekonomi, ada dari perspektif budaya dan lain sebagainya. Setelah itu ke pertahanan, keamanan. Setelah itu baru kemudian akan dilakukan public hearing. Jadi penjaringan aspirasi seperti itu. Ya betul. Cuman memang kalau di mereka tidak ada. Do you have any specific report or before? Usually in us, the bill is assisted with the report like hundreds pages, analyzing each article whether this is relevant or not with our country situation. Do you have the same like this?
We have it, but it is not detailed.
It's not
so
detailed.
You have the bill, but you have the committee report. And the committee report will just say, we like this bill.
Okay.
Because of so reason.
Yeah, the report is not coming from the government, but from the legislative. Okay. In our side, we also have it from the president, from the executive. Jadi kalau di mereka nggak ada kajian akademik, tapi adanya kajian atau putusan yang diberikan oleh masing-masing panitia khusus dan juga rapat-rapat DPR yang lain termasuk public hearing itu. Ada lagi? Saya kira itu saja ya. Is there any one question?
Yes, last question.
Yeah, last question.
So this question is very important, it's very good. Whether pre-colonial Nigeria, colonial Nigeria, and post-colonial Nigeria, international law are the same or different? They are not the same. Pre-colonial Nigeria, at that time, there was no Nigeria, only empires and kingdoms. So they decide the kind of treaty that they want to enter into with neighboring communities. So, and don't forget that during that period there was no development. Even international law did not develop. So mostly the type of treaty that they have is treaty relating to war, relating to trading, then treaty relating to maybe ambassadorial practice or diplomacy. But colonial treaties, those were treaties that were entered by the British on behalf of Nigeria. And those treaties were made to consolidate the power of the British over Nigeria. So any treaty that is important to them, international law provision that is good for them, they adopt it in Nigeria. If it is not good, they will not adopt it because they are exploiting Nigeria, at that moment. But post-colonial treaty was more about diplomacy because Nigeria has come of age. So it entered into a lot of international law provision relating to cooperation, science and development, and you tend to see most of these treaties were meant to help Nigeria because it was growing. Then after that, international law after 1945 has developed in relation to human rights issues, in relation to protection of environment, in relation to rights of states. So at that moment in time, post-colonial international law provisions and treaties, Nigeria adopted them because it needed. It needs most of these treaties for its own development. So that is the nature of the treaties that we have. They are different. Pre-colonial different, colonial different, and post-colonial treaties equally different.
Okay. Ya, sudah jelas ya. Tadi pertanyaan dalam bahasa Inggris, jawabannya dalam bahasa Inggris. Oke. Siap, saya kira itu teman-teman semua. Tadi yang tanya selain Hazik siapa? Yang pojok sana siapa tadi namanya? Dea ya. Dea 24110 585 terus Fania 24110 530. Thank you very much for your participation.
Yes,
and again,
thank
sir.
them for the question. They are very good questions.
Yes, of course. Thank you very much again for delivering all the explanations about how the international law application in Nigeria. And let's we close our session today by hamdalah. Alhamdulillahirrabbilalamin. Untuk summary-nya, ketua kelasnya siapa hari ini di sini? Kamu ya? Siapa? Hah? Hah? Sidki ya, udah nggak apa-apa, Sidki aja. Ya, latihan jadi ketua kelas. Oh ya, kita foto dulu, Mas Afik minta tolong difotoin dari sini. So we stand up here, and they will stand up, and then they will.
It's